The ranking member and I are here, and we're ready to begin with our all-woman panel. I have to tell you before I do anything else that the ranking member just told me that when he was sheriff in Washington State, his entire command staff was female, and many of his other jobs were key jobs were held by females, and that, of course, is why he was successful. The subcommittee is meeting today to receive testimony on H.R. 6193, the Improving Public Access to Documents Act of 2008. From the start of the 110th Congress, this subcommittee has focused on two huge obstacles to accurate, actionable, and timely information sharing. First, our nation's broken classification system, and second, the explosion in the number and use of sensitive but unclassified control markings. Later today, the subcommittee will take legislative action to address these twin problems with a markup of H.R. 4806, the Reducing Overclassification Act of 2007, and a new bill that is the subject of today's hearing. Last Thursday, Dave Reichert and I were joined by 6 other members of the Homeland Security Committee in introducing H.R. 6193, the Improving Public Access to Documents Act of 2008, the so-called IPAD Act. The IPAD Act will give life to the newly released Controlled Unclassified Information Framework, that's a mouthful, prepared by the Program Manager of the Information Sharing Environment, Ambassador Ted McNamara, who is well known to this subcommittee and who testified before us on this subject last spring. Wherever you are, Ambassador McNamara, we commend you for crafting a framework that appears to be a workable replacement for the out-of-control SBU practices, policies, and procedures that have plagued the federal government. Indeed, some 28 distinct policies for the protection of sensitive but unclassified information presently exist. And security experts believe that there are more than 100 individual agency control markings that have stymied both the sharing of unclassified information within the intelligence community and disclosures of that information to the public. Unlike classified records, moreover, there has been no monitoring of the use or impact of SBU control markings. Ambassador McNamara's CUI framework promises to bring order to the chaos, and Ranking Member Reichert and I and our members want to help. The legislation we've put together requires the Department of Homeland Security to adopt the new CUI framework implementation plan with rigorous policy development, training, and auditing requirements. Accountability is what will make this new approach succeed, and the IPAD Act is aimed at getting it right. After working together on the bill for months, and now with significant input from the privacy, civil liberties, and government oversight communities, we believe the legislation will make DHS the gold standard when it comes to getting the CUI framework up and running and working. The potential dividends for more and better Homeland Security are enormous. Implementing the new framework at DHS will not only improve information sharing with the department's state, local, and tribal partners, but also will help decrease the exorbitant information security costs that the current SBU regime imposes and undo misguided SBU control marking practices that needlessly limit public access to information. Bottom line, doing this will improve public access to information. The public has a right to know about material in many of these documents, and these markings cannot be an excuse to cover material up to protect somebody's either political interests or mistakes. That's why I'm glad to be joined by our 3 female witnesses today. Each will be sharing her views on how the IPAD Act will promote not only more robust information sharing within government and with the public, but also more transparency regarding how our nation is working to secure itself from terrorist attacks. That transparency will foster greater public confidence by requiring DHS to keep faith with the Constitution and the rule of law as it does its work. That may sound a little trite, but keeping faith with the Constitution and the rule of law may have been lost in some of these overclassification and pseudo-classification exercises in recent years. I want to thank our ranking member and our other members for supporting the critical legislation and look forward to the witness's testimony this morning. And I now yield to Sheriff Reichert, employee of many senior females in his past occupation, for his opening remarks.
Thank you, Madam Chair. And I do have to say, we've in the last year and a half have developed a great friendship and a great working relationship, and it's built on trust. And I think as you hear my opening statement, I'll mention that because I think the information sharing system is a system that must be built on trust also, and I think that everyone would agree to that. So, and there's all, there's a lot of directions that we come at this, but it's been a joy and a pleasure to work with you, Madam Chair, on this issue. And both of our hearts are in a place where we really believe that this legislation and some of the others that we'll consider today is very, very important to the protection of our country, our community, and also the protection of our civil liberties and the rights that we enjoy under the protection of the Constitution, guaranteed to us by the Constitution. And my job as the sheriff was, of course, make sure that those laws were enforced and that we did protect people and ensure that their rights were protected too. So here I am in a little different role, but certainly understanding where we're going with this. I've worked with this at a local level with a lot of federal agencies. So I want to thank you all for being here today to talk about H.R. 6193, the Improving Access to Public Disclosure or Public Documents Act. I applaud the intent of this legislation to make sure that information that needs to be protected remains protected and information that should be disclosed is available to the public. It is essential that the brand new Controlled Unclassified Information CUI framework is successful. Designating a document CUI to protect sensitive information will directly help fix the overclassification issues and problems that are rampant in our federal government. Currently, agencies often overclassify information as secret because they do not trust the protections for official use only and sensitive but unclassified. Because misunderstanding these markings often leads to public disclosure of sensitive information, agencies would rather stamp secret on the document because they know it will be protected. Consolidating all of these legacy markings under the new CUI framework will help our federal government protect information in a way that allows for quick sharing with state and local law enforcement and other public and private stakeholders that may not have clearances. But as I've heard and experienced over and over again, information sharing, as I said earlier, is really about trust. We need to ensure that when we implement any final CUI framework, it will not only apply to the Department of Homeland Security, but all government agencies. We cannot have the FBI, the CIA, and other federal law enforcement and intelligence agencies distrusting the process and keeping their information from DHS. And that is a concern that I think both the chair and I share. As I said, I've witnessed some of this in my days as the sheriff. Information sharing breaks down in the same, as you work with other agencies, if you have a different set of standards. I've discovered that the FBI, DEA, ATF, of course, when they supply information to the sheriff's office back in my days, they were then subject to the public disclosure laws of the state of Washington, and therefore the information they shared with us was open to request, and so there was a reluctance then to share that information. However, we were successful in some instances in prying that information loose. It was not easy, however. So I look forward to working with all of you. Sure appreciate you being here this morning, and I look forward to your testimony. And again, just been a pleasure to work with the chairwoman on this, on these important bills. I yield back the balance of my time.
I thank the ranking member for his comments. Moments of bipartisanship are all too rare around here. And as I was telling our witnesses just before the hearing, I expect that we will not only have bipartisan support for this bill and the others I mentioned, but unanimous support as we mark them up later today. Everyone should focus on that short moment because come tomorrow, other things may overtake this. But this is what Congress should be about, in my view, and that is working together to solve hard problems, and I believe we have a very good solution before us. Other members have not arrived, so I don't need to announce that their statements will be inserted for the record. I welcome our witnesses this morning. Our first witness, Meredith Fuchs, is the General Counsel of the National Security Archive, an independent non-governmental research institute and library at the George Washington University that collects and publishes declassified documents obtained through the Freedom of Information Act. I was talking to Ms. Fuchs about one of the founders of the National Archives, Scott Armstrong, who has been a witness before us and who is a valued friend and has been consulted by us often as we develop not just this legislation but other things. And I just want to send my warmest wishes to Mr. Armstrong. Ms. Fuchs previously was a partner with the law firm of Wiley, Ryan, and Fielding here in Washington, where she developed a significant e-commerce and privacy practice. She's a frequent lecturer and author on both data privacy and e-commerce liability issues. Formerly a Supreme Court Assistance Project Fellow with the Public Citizen Litigation Group, and also a law clerk with the U.S. Court of Appeals for the District of Columbia and the U.S. District Court for the District of Columbia. She's a graduate of New York University School of Law. Our second witness, Patrice McDermott, is the director of OpenTheGovernment.org, an organization that seeks to advance the public's right to know and to reduce secrecy in government. She previously served as the Deputy Director of the Office of Government Relations at the American Library Association's Washington office, where she had lead responsibility for government information and privacy policy and e-government policy issues. Ms. McDermott has also served as the Assistant Director for the Office of Intellectual Freedom of the American Library Association, taught information politics at Clark Atlanta University, and worked at the National Archives and Records Administration. I've got it. She has her doctorate in political science from the University of Arizona. This is a lot of material. You have to, I'm getting choked up. And is the author of Who Needs to Know? The State of Public Access to Federal Information. Our third witness, Caroline Fredrickson, is the director of the Washington Legislative Office of the ACLU. She is the organization's top lobbyist and supervises a nearly 60-person team in promoting ACLU priorities in Congress. Ms. Fredrickson has years of experience as a senior staffer on Capitol Hill, having previously served as Chief of Staff for Senator Maria Cantwell and as Deputy Chief of Staff to Senate Minority Leader Tom Daschle. In 1998 and 99, she was Special Assistant to the President for Legislative Affairs, a position that required her to work closely with both parties in the Senate to forge bipartisan agreements on the White House's legislative priorities. Ms. Fredrickson is a Columbia University Law School graduate, where she was a Harlan Fiske Scholar. Without objection, the witnesses' full statements will be inserted in the record, and I understand we have some letters of support for the bill from both the organizations you represent and other organizations. Without objection, they too will be inserted in the record. I now ask Ms. Fuchs to summarize her statement for 5 minutes, and I would point out that there's a little clock that will start ticking off the time. When it starts blinking red, please conclude. Please turn on your microphone.
Good morning. Thank you for this opportunity to testify about the Improving Public Access to Documents Act of 2008. I represent the National Security Archive, a non-governmental research institute at George Washington University. The archive conducted a government-wide comparison of sensitive but unclassified control label policies in 2006, and we concluded that the SBU practices of agencies could interfere with information sharing and be abused for administrative convenience or to cover up information. As a leading nonprofit user of the Freedom of Information Act and other programs designed to release information, the archive is concerned about the impending implementation of the Controlled Unclassified Information Framework that is described in the President's May 9th memorandum. I'll call it the CUI framework for short. I've submitted written comments for the record, and this subcommittee is already well aware of the dangerous impact of the proliferation of sensitive but unclassified record control labels, and both on information sharing and public disclosure. So in my summary statement today, I'd like to focus only on a couple of key points. First, the CUI framework perpetuates and extends a system of information control that's been abused in the past and left us vulnerable to harm in the past. While the establishment of trusted pathways for information is obviously essential to coordination amongst federal, state, local, and tribal governments and private parties, those pathways are susceptible to manipulation and failure, just as individual agencies that jealously guard their secrets and turf. True information sharing is best accomplished by the elimination of unnecessary secrecy and the minimization of information controls. The perspective adopted in the CUI framework that the public should be left out of Homeland Security and terrorism matters ignores the reality that the public will be affected by any attacks, has an interest in preventing attacks, and needs information to protect their families when first preventers and first responders are unavailable. Think about the crime reports that most of us receive in our communities. When we learn that our community is being targeted, we can take measures to protect ourselves. In other words, sometimes information should be made available to the public, not because of a Freedom of Information Act request, but simply because the public needs it. I hope the CUI framework does not lead to situations where such information is withheld or delayed because of fear that it should stay secret. Thus, the provision in this bill requiring DHS to consult with public interest organizations helps bring the public back into the recognized stakeholder community. Although the CUI framework itself has laudable and important goals, it does not include measures to reduce information control, labeling, and secrecy. And several of the provisions of H.R. 6193 that are designed to discourage unnecessary labeling are much needed. And we hope they are included by in the National Archives implementing regulations for the CUI framework. In particular, the establishment of a system for employee challenges to improper labeling, including incentives and rewards for challenges, is an internal check on abuse. The requirement that a list be maintained and available of records with CUI labels and the provision for Inspector General audits will remind information controllers that their decisions are subject to review. In addition, limiting the number of controllers will ensure that those who are granted the authority to put a CUI label on a record can be better trained and supervised. I suggest one other measure be considered. The CUI framework does not provide any substantive definition of CUI. It merely is information pertinent to U.S. national interests or other important interests that requires protection. That's a broad description, and it is eventually going to be defined within each agency based on the type of information that agency handles. Agencies will be far more likely to define categories of CUI in a narrow fashion if their designations are subject to public review and comment. Accordingly, I recommend that DHS be required to provide transparency as it develops its substantive criteria for a CUI label. My second concern, and I'm going to close with this one, is that the CUI framework will have an impact on FOIA decision-making. The CUI label, in fact, should not really inform or otherwise influence FOIA release decisions, and this bill is helpful for making that clear. The CUI label has no duration, it does not recognize changes in factual circumstances, it doesn't consider a FOIA requester's identity or their reason for requesting the records, or changes in FOIA policy concerning discretionary release of information. And there's no basis in FOIA for any other statute to add as a new criterion a CUI label. Each of those items that I talked about are things that are considered in FOIA release decisions, and with a CUI label being considered, it could wait against release. I spelled out more details in my written statement about this, and I will not repeat them now, other than to urge you to make the legislative history on this point clear. CUI should not have an impact on FOIA. This bill provides protection against abuse of the new CUI framework and would make the framework work better. I do hope that it will be adopted government-wide, and I thank you for permitting me to testify, and I'm happy to respond to your questions.
Thank you very much. Ms. McDermott, please summarize your statement in 5 minutes.
Thank you. Good morning. Thank you, Chairwoman Harman and Mr. Reichert, for the opportunity to speak today on the proposed legislation. Thank you. In March 1972, speaking about his executive order on national security classification, President Richard Nixon noted that when information which properly belongs to the public is systematically withheld by those in power, the people soon become ignorant of their own rights, distrustful of those who manage them, and eventually incapable of determining their own destinies. He had it right then, and it is still true now. A month ago, as you know, the White House issued a memorandum to all heads of executive departments and agencies that intends to contain and constrain the proliferation of unclassified control markings within the information sharing environment. The goal is to standardize practices to facilitate and enhance the sharing of what is now called controlled unclassified information, but only with and among those who are already sending and receiving it. I would like to make 3 points about the implementation of that memorandum, with a focus on your legislation to direct how it is implemented at the Department of Homeland Security. First of all, the default must be openness. We are very pleased that you have designated your legislation as the Improving Public Access to Documents Act, although, as you know, the name alone will not determine the reality. As noted in the findings section, the proliferation of SBU control markings needlessly limits public access to information and increases the costs of information security, which are already extraordinarily high. Indeed, assessing the costs associated with creating and safeguarding CUI are something that you may want to consider adding to the important auditing mechanism that this bill creates. The White House memorandum makes only a minimal nod toward public access and no acknowledgement of the benefits of openness to our society and to our safety. This bill takes important steps toward ensuring that those benefits are considered in decisions about whether and how to put controls on access and disclosure of information that might be considered CUI. The default bureaucratic position is to not take risk. Unfortunately, that message has been given to officials in our government that openness is risky. This is not only a dangerous mindset in an open society, but as you note, it stands in the way of a safer and more secure homeland. We are all agreed that there is information that does need to be protected for some time. The tension, though, is not between openness and security. It is between information control for bureaucratic turf, power, and more than occasionally political reasons, and the reality that empowering the public makes us safer. To counter the impulse towards non-disclosure, the bill has 3 provisions we think are very important. We urge you to protect these provisions throughout the legislative process to ensure their inclusion in any final legislation that may be signed into law. The first of these establishes that CUI markings are not a determinant of public disclosure pursuant to FOIA. As I noted in my submitted written testimony, a 2006 GAO report clearly indicated that agencies think of the several FOIA exemptions, the current FOIA exemptions, as creating control categories. They consider them CUI. The effect on access to information through FOIA has been pernicious. To ensure that this provision is properly implemented, the legislation contains 2 critically important requirements: to maintain a publicly available list of documents designated and marked in whole or part as CUI, and indicating which have been withheld in response to a request, and to create a process through which the public may seek the removal of such a designation and marking. That is entirely, both of those are entirely absent in the White House framework. This list of documents is essential not only for ensuring that CUI markings do not preclude disclosure under FOIA, but as a critical tool for oversight and for maintaining a check on agencies' demonstrated impulse to over-control and over-designate information. From our perspective, the focus on FOIA, while critical, should not obscure that this is a fallback channel for public access to agency information on Homeland Security and related topics. If disclosure under FOIA is seen as the primary alternative to classification or control, an impossible burden may be placed on the FOIA process. The second key set of provisions concerns controlling the controllers, and Ms. Fuchs has addressed some of these. The tracking of employees' markings and use, and the ability and the requirement that the department consult with outsiders, with other stakeholders, and also that that this plays a role in determining how many people have or designation authority. We also urge you to protect throughout the legislative process, as Ms. Fuchs noted, the inclusion of outside groups, public interest groups, because these help to promote trust and accountability. And thirdly, information sharing must include the public. We have experienced a trend in our country away from trust in the public to a need-to-know mindset, and we need to move away from that, and this legislation takes an important step towards doing that. We look forward to opportunities to work with you on this bill and to ensure that this legislation begins the process of ensuring that public access to documents, including CUI, is truly improved. Thank you again for this opportunity, and I will be pleased to answer any questions.
Thank you very much. Ms. Frederickson, please summarize your testimony in 5 minutes.
Good morning, Chairwoman Harman, Ranking Member Reichert, and members of the subcommittee. Thank you so much for this opportunity to testify on behalf of the American Civil Liberties Union about an issue of critical importance to all Americans, the right of the people to know what our government is doing. And I also would say I appreciate very much the opportunity to testify with such a distinguished panel. We testify today in support of the Improving Public Access to Documents Act of 2008, which would create a more accountable government by compelling the Department of Homeland Security to develop policies to limit and regulate the federal government's use of control markings on unclassified documents. This important bill makes clear that controlled unclassified information, or CUI, can be shared with state, local, and tribal governments, the private sector, and the public as appropriate. Our nation has often faced grave threats to our security, but has recognized that abandoning our fundamental democratic principles does not make us stronger. During the height of the Cold War, President John F. Kennedy said, "The very word secrecy is repugnant in a free and open society." We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify it. Despite the near universal recognition that the failure to effectively share information was a contributing factor in the intelligence breakdowns that led to 9/11, government agencies have increasingly been using unregulated control designations that restrict the free flow of information and increase confusion regarding what information may be shared, with whom, and how. Testimony before this subcommittee last year revealed that 20 federal agencies use at least 107 different control markings. All the information subject to these 107 unregulated control markings is, by law, unclassified. Federal agencies began using control markings on unclassified documents they considered sensitive in the 1970s. But the term sensitive but unclassified, or SBU, has never been defined in statutory law. Last month, the White House issued a memorandum that adopts CUI as the sole SBU, excuse me for the acronyms, designation for the federal government. The executive order seeks to standardize practices and thereby improve the sharing of information, not to classify or declassify new or additional information. The ACLU has grave concerns that once a CUI framework is developed, officials could ignore this lofty purpose and use CUI markings to improperly withhold unclassified documents from public disclosure. That's why legislative guidance is so necessary to ensure that government officials use CUI markings to increase information sharing rather than restrict it. Any legislation that establishes a legal framework for controlling unclassified information must be drafted carefully to ensure that it does not inadvertently create a secondary classification system that further restricts the public's access to information. The Improving Public Access to Documents Act accomplishes this feat by requiring the Secretary of the Department of Homeland Security to develop CUI policies that, quote, in order to maximize the disclosure to the public. Requiring DHS to coordinate and consult with the archivist of the National Archives, state, local, and tribal governments, as well as civil liberties organizations and the private sector will ensure that all stakeholders have a say in the development of these DHS policies and procedures. Congress recognized the public's right to information held by our government when it passed the Freedom of Information Act in 1966. And voted to strengthen it in 1974, 1976, 1986, 1996, and again last year. Your bill includes two critically important provisions establishing that CUI markings are not allowed to undermine FOIA and ensuring public access to unclassified information, even if marked CUI, under an appropriate FOIA request. These must be included in any legislation that may be signed into law. The bill properly limits what types of information may be designated CUI and prohibits use of CUI markings to conceal violations of law or prevent embarrassment to an agency. The bill includes many other important provisions that my colleagues have mentioned already, so I will conclude by saying that we are very happy to support the Improving Public Access to Documents Act of 2008 and look forward to working with you to see it move to statute with all of its provisions intact. Thank you.
Thank you, Ms. Frederickson. And I thank all the witnesses for observing the time limits and welcome 3 more members who are here to ask questions. They will be recognized in the order that they arrived after the ranking member and I ask our own questions. I now yield myself 5 minutes for questions. Everyone probably knows that the formal name of this subcommittee is Intelligence, Information Sharing, and Terrorism Risk Assessment. Information sharing, all of us believe, is an absolute key to getting and sharing intelligence with those who need to know it. So we have been hammering on government agencies and others for the better part of 2 years to break down old cultures. One of you mentioned the need to know culture, which is still sadly alive. It must change to a need to share culture. That is certainly a premise that underlies a lot of the work we have been trying to do here, and I'm pleased to hear that all of you support the work we're doing on this legislation. Let me just ask 2 questions, because I want to respect the time of others. Number one, as I made clear in my opening remarks, we are trying to make DHS the gold standard with respect to implementing these new guidelines. We're doing that for 2 reasons. One, we think that DHS has critical jurisdiction and is part of the problem and should change for the better. But the second is we have jurisdiction over DHS. That should be obvious. One of you mentioned that this should be a government-wide policy, and I would just like to hear some more support for that position or your additional comments on that. That's the first thing. The second thing, one of you said that a reason that many hide information or stamp information with protective categories is bureaucratic turf and power. I obviously agree with that, but I'd like you to explain that. And let me just add one thing to that. As a member of the House Intelligence Committee for 8 years, from 1996 with a little interruption until 2006, I came to respect enormously what I think is a good reason to protect information, and that is to protect sources and methods. People die if sources or methods are disclosed, and especially if on an ongoing basis we're trying to learn the plans and intentions of bad guys. We have to protect our sources and methods. But I never could find another good reason for protecting information. So I don't personally think that bureaucratic turf and power are good reasons. And I would just welcome, again, some comments to fill out our record. So both of those are my questions and my only questions. One is, should this approach that we're taking apply government-wide? And the second is, please explain your comments about bureaucratic turf and power, and let us know if you think there are any good reasons other than protecting sources and methods to hide information from the public. Ms. Fuchs.
I'd be happy to start off. I think that the reason that these standards need to be applied government-wide is that while certainly DHS is critical in terms of the information sharing environment, the reality is there are other agencies, law enforcement agencies, intelligence agencies that do participate in the information sharing environment, and they all have similar problems to DHS. The CUI framework that the President has established certainly provides some very positive aspects in order to increase information sharing, but it really doesn't provide protections against it being abused. And I think that this bill includes many of those protections. And we hope to make similar comments as we've made today to the National Archives to let them know that we would like to see this in their implementing regulations if it does not become government-wide statute. And then simply to respond on the question about bureaucratic turf and power, I mean, we see examples again and again in the classification realm where information is improperly classified, and when you actually see the information, the only reason that you can identify classification was because they were embarrassed or they didn't want people to know the position they were taking. You know, a good current example is some of the memos that were written in the regarding torture and detention that were classified, and now that those memos, parts of them are being made public, it's clear that at least what was classified probably could have been made public. And my understanding is for some of these memos that justified surveillance, you know, not even general counsels within government agencies were allowed to look at those memos. That doesn't make any sense to me. To me, that's clearly about power and not a proper use of a classification stamp.
Thank you. Other comments?
Well, I think I'm the one who said that they tend to stamp for bureaucratic turf and power. And I know anecdotally, obviously I'm not inside the government, but we heard in relation to the events of 9/11 that information was not shared, unclassified information even was not shared. We have seen in the GAO reports that there is great difficulty in across government and from government to other levels of government in sharing information. And it appears to be that it is about controlling information in order to keep it within the control of a particular bureaucracy, rather than letting it get out to other agencies who may do other things with it or may release it. So I think this is from what GAO has reported and what we hear in the newspapers and what you have heard and released here in the Congress, this is a severe problem with control for its own sake and also control for avoidance of risk, which is the flip side of that. We do agree that we would hope that the provisions in this bill do become government-wide policy. Because, as I noted in my written testimony, there are many important provisions in here, the auditing and the tracking, the encouragement of people to challenge markings. We would add, as I do in my written testimony, that there need to be whistleblower protections for those people as well. But DHS is a poster child for non-disclosure and non-transparency at the moment, and if you could make DHS the gold standard, we think that will set a very strong example, and we also will be working with National Security Archives and our other partners in the coalition to encourage the National Archives as they implement the White House framework, the CUI framework, to adopt some of these policies that are contained in your bill.
Thank you. Ms. Frederickson?
I associate myself with the comments of my colleagues and only add one thing. I think, as Patrice rightly said, it's not simply bureaucratic turf battles and control and urge for power, but there's also a fear of risk, and I think your legislation addresses that very well by limiting the number of individuals that actually can designate the documents CUI, and also makes them accountable. Having the list of documents published, I think, is a very important mechanism for ensuring that people don't, out of fear or risk-averse tendencies, decide to keep everything secret if they can. So thank you for that.
Thank you very much, and I'm aware that the answers of witnesses went over my time limits, so I will afford other members the same courtesy. Mr. Reichert.
You have that prerogative, Madam Chair. I want to thank you again for being here today. A lot of things that you all three of you said, I just kind of brought back flashes of my previous career and various things that we confronted as far as information sharing and withholding of information. I started in law enforcement back in 1972. Don't worry, I'm not going to go through my whole career. But I did have dark brown hair, by the way, back then. You know, there was a problem then when you worked, there were street crimes units who worked on street crime, which included a variety of crime, and then they worked with a drug unit that worked on drug crimes. There was an inability or an unwillingness, I should say, for those units to share information because there was a turf battle, and there is, it consists today, but you rise above that, the local competition there between two units within a police department or a sheriff's office, and now you're talking about sheriff's offices and police departments that don't share information between the two of them, or especially in the Green River case back in Seattle, where many agencies were involved, and there was a fear of sharing information because they would be tied to the investigation. The news media would be all over their backs then saying, what are you going to do to solve this case? And they wanted to stay out of it. I mean, they just go on with the reasons, but I clearly understand this issue. But I also want to point out that we've made great progress since those days. The fusion centers that exist today, the WAJACs that exist today, the Joint Terrorism Task Force, there is this effort now for agencies to share information between themselves. But I agree with you, after September 11th, as the sheriff in King County, we had struggled greatly with the federal government to share information with law enforcement leaders. I had 1,100 employees that needed to know certain things were happening, and we were not told. The police chief of Seattle will tell you the same thing happened. The state patrol chief will tell you the same thing happened there. So not only do the law enforcement agencies need to have that information, but I agree with you, the public does. And in the fusion centers, we have included people from the public, from various businesses and other public entities in the communities now are all a part of our fusion centers and sharing information. I would like, you made a comment, Ms. Fredrickson, on the risk of fear. What do you exactly mean by the fear of risk, I should say? What do you mean by that?
Well, I think it's commendable, and many in law enforcement and in our government really want to keep us safe, and I think we all appreciate that. I think, though, there may not be an appreciation of the fact that sometimes, I think, as Meredith said specifically, that it's actually providing of information that keeps us safe. And so that's why it's very critical that I think we overcome some of what may seem to be risk-averse tendencies of people to keep things classified or keep them secret or keep them away from the public. And that has very pernicious consequences when that information is not appropriately withheld.
Do you think there's a fear of lawsuits?
There may be. That's really not what I was thinking of specifically, but I think I'm thinking of their higher intentions, that there actually is a real desire to keep us safe, but that sometimes it may be misleading in the sense that it leads to actions that actually undermine our safety. Yeah.
Well, a question about FOIA requests. About how many requests do you think are made a week, if anybody on the panel would know? How many? Do you know how many a week, a month, or is there? Do you keep track of the number of requests made?
Yeah, there's government-wide. There's something like 20 million. Is that correct?
Yeah, I think that's right.
But that includes Privacy Act requests, which are when people, veterans ask for their own records. In terms of FOIA requests, it's probably a couple of million each year, and they wide range in terms of how complicated or not complicated they are.
Are you getting? Do you feel like you're getting prompt responses, or
No.
This response I expected, by the way.
I planted this question.
My organization, in fact, has done several studies looking at the oldest FOIA requests in government, and in fact, there are some that are 15, 18 years old. Yeah. Of course, those are the hardest ones, and as you know, there was legislation passed last year and enacted into law that we hope will help improve FOIA responsiveness. But of course, anything you add to the FOIA consideration process is going to slow it down. And that's one of the reasons why it's so critical that CUI not be yet another hurdle that FOIA requesters are going to have to get past in order to get their information.
Yeah, I had the same experience in the sheriff's office with public disclosure requests. They can slow down your entire organization. So I do have a concern about that, and hopefully we can work together in lessening our fear of how that might affect FOIA requests. I yield back. Thank you, Madam Chair.
Thank you, Mr. Reichert. Mr. Carney of Pennsylvania is now recognized for 5 minutes.
Thank you, Madam Chair. I suggest also that one of the reasons we see overclassification sometimes is fear of embarrassment, politically embarrassing things. In my experience at the Pentagon over a number of years, I did see some of that occur as well, and I think that's awful. You know, we've got to get a handle on that. We've got to find ways to manage it. But we're talking about DHS today, and what is there some of that actually in this overclassification? Do you think hiding politically embarrassing things? Anybody feel?
Well, I mean, I certainly think that there is some of that. I mean, a good example of that would be the Taguba report that first was looking at treatment of people in Abu Ghraib, which was largely classified, and obviously there may have been, you know, aspects of what happened that needed to be classified. There also may have been reasons to manage how the information was released, but in fact, most of it did not require classification and eventually was released. So I think there's numerous examples of the attempt to cover up embarrassing things that happened. But of course, the reason we have these open government laws is to expose those things so we can do better. And that's why it's so important not to let that happen, and why it's so important that this bill has provisions for looking at the decisions to label and then taking steps when it's improperly done.
I agree that certainly with overclassification, and to the extent that we can tell with the CUI markings, that's a very high risk because there has been no control on them. There's been no control on who can create them. There's been no mechanism for removing them. At least with classified information, there are processes. So I think that's a very high risk, and that they are for hiding embarrassing or inconvenient facts. And so I think that's very important. And I would also like to note that in terms of the FOIA, I know this wasn't your question, but if information is made proactively available by agencies that can be made available, it releases the need for FOIA.
And at the risk of repeating something that Meredith said earlier, I think I wouldn't necessarily classify it as embarrassing information. But the torture memos, or the memos about interrogation methods that were prepared by the Office of Legal Counsel, obviously there again may be sections of those that could have remained classified of what we haven't seen yet. But really, this is information that we need to know, and the reason that it was classified was not because of it was an essentially document that needed to remain. Be withheld from the public, but really because I think that the legal analysis that was provided in those memos was so faulty.
From a DHS perspective, what do you see as the key DHS barriers to compliance with the Public Access Documents Act?
I think the people I've dealt with at DHS seem like they have a genuinely strong intent to try to get better control over their information and to handle it properly, although I know that other agencies actually have a lot of problems with how DHS has handled information. So I think that, DHS continues to struggle with the same problems that it's had, which are that it's a very large agency with lots of different missions and components. And the CUI framework is going to require them to get some organization. I think Chairwoman Harman mentioned, bringing order to the chaos, and I think that is a big challenge at DHS and will continue to be so. However, by reducing the number of controllers so you can focus on the people who are going to put the labels on the information, and by training them and supervising them properly, I think it will have a good impact.
I agree with Ms. Fuchs that there are good people with good intent in the department, but I was the one that said that they're the poster child of non-transparency, and they are. It's impossible to find information on their site. I have bookmarked regulatory information, submitted comments, and gone back the next day and they were gone. They were unfindable. And so I think it's going to be a serious challenge for the department to implement this in a transparent and open manner, and I think it's going to take continual oversight. Again, I agree with Ms. Fuchs that there are good people with good intent, but the tendency of the department is not toward transparency, maybe with other agencies, but not with the public.
And just quickly, I think I'd just like to comment that the legislation that we're discussing today is actually not just an open government bill, but also a good government bill, in the sense that I think there are real efficiencies in reducing the number of designations that are allowed, and I think the cost savings that could result from government actually being able to talk to other elements and getting the influence or advice of outside stakeholders is very critical to making it work better, and so we support it on that basis as well.
Thank you. No further questions, ma'am.
Thank you. I would just note for the record, as we discuss documents that supposedly explain the legal framework for government programs, that as a member of the Intelligence Committee all those years, we continually demanded to see those documents. They were never shown to us, at least during the time I served on that committee. And on this committee, we have had an ongoing request to DHS about the legal underpinnings of the proposed National Applications Office, the NAO, which will task military satellites to do surveillance activities over the United States. We think that may pose some problems under posse comitatus and some other issues. But at any rate, that conversation is ongoing. We're not satisfied that we have seen a document explaining the legal underpinnings, and that document should be available to Congress, which has responsibility for faithfully executing the laws, and the public should understand what the legal basis for government programs is, in my view. I now yield 5 minutes for questions to Mr. Dent of Pennsylvania.
Thank you, Madam Chair. From your viewpoint, is there sensitive but unclassified information out there that needs to be protected, or do you believe that that all unclassified information should be releasable without restriction by the government, even if that information is sensitive? I'd just be curious to get your thoughts on that, starting Ms. McDermott.
Oh, absolutely. There's controlled unclassified information that does need to be protected for at least a certain amount of time. And I think the framework, the White House framework, is intended to do that. And I think that this bill takes important steps toward building in provisions to ensure that that is reviewed on a regular basis. And the framework also includes portion marking, so that where there is a document, a portion of which needs to be kept safeguarded for a particular amount of time, that portion can be separated out and shared with those who need to have only that protected information, but the rest of the information can be shared more generally with the public. So absolutely yes, but as with classified information, most classified information also has a shelf life, except for sources and methods, and there needs to be opportunities to review it and to remove the controls.
Ms. Fuchs or Ms.
I agree. I think that there is a need for some controls. I mean, to take it away from the specific information we're talking about, it's just like in any business, there's certain information you don't leave on your desk. And certainly CUI information, whether it's privacy information or it's information about a law enforcement investigation, it shouldn't be left around for, the janitor to pick up. That's absolutely clear. And what I think we advocate for, though, is understanding what really needs that protection and not spending time and money on things that don't need that protection. And that's why I think the CUI framework is necessary. But this bill, fortunately, would make sure the CUI framework does not become so broad that it pulls in too much information.
Thank you. Ms. Frederickson.
I don't have too much to add to that. I entirely agree with the previous comments. Just to say, I think it's important, as the chairwoman mentioned, that we need to move from a need to know to a need to share system, that the presumption has been too much on the side of non-disclosure. So where there are categories that are clearly there is a heightened sensitivity. There needs to be a heightened sensitivity, the need to disclose as much as possible.
And my next question then really deals with, well, the legislation that we're discussing today, H.R. 6193, applies only to Homeland Security Department. Do you think that a CUI framework should be established throughout the entire federal government? And if so, what do you think is the best way to establish such a framework, and what sorts of standards should be set in establishing that kind of a framework? Starting in, anybody want to take a shot at that?
Sure. I think we spoke to that a little bit earlier, and I think there's general agreement that it should be government-wide. And this bill provides, I think, a very good framework for expansion to other parts of the government.
Well, I think we're all agreed that the current situation with what we've previously called sensitive but unclassified information is untenable. It's untenable for the government, it's untenable for the public, it's untenable for other governments who need to get information from the government. So a framework to deal with this is essential. And the White House memorandum has established sort of the bare bones of that. And we're pleased that the implementation has been put in the National Archives, which has a commitment to openness, and would very much like to see most of the provisions of this bill adopted by NARA as it goes out to the information sharing environment, and then as other agencies adopt this framework.
I would just agree with what my other co-panelists have said.
That's fine. I'll yield back. Thank you.
Thank you, Mr. Dent. Mr. Langevin is now recognized for 5 minutes for questions.
Thank you, Madam Chair. I want to thank our witnesses for the testimony today, and especially want to thank the Chair for holding this important meeting, this hearing today. The Chair and I both have an appreciation for and a love of intelligence work, and we can deeply appreciate the issues associated with and need for classified information. But equally important, we share an understanding that we need to get the information into the hands of those who need it, and equally important, giving the information to the public for their understanding of information as well. Most of the questions that I had have really already been asked, but I do have a question of with respect to how we proceed from here as we move forward with the implementation of the COI designation. What are the most important things that Congress should be doing to ensure appropriate oversight? What do you see we need to do in terms of overcoming the likely challenges with the implementation of CUI?
That's a very good question, I think. That's obviously been a challenge for Congress for the past several years, in oversight with this government, particularly with its inclination towards secrecy, I think has really impeded a full and thorough oversight process. But I think the engagement of this committee and your commitment on the issue, I think, is clearly a very, very good step in the right direction. And maintaining your attention on these issues, I think, will be required. I think, as Patrice had suggested, it will be a real task, I think, to push DHS forward and to ensure that the language of the legislation is actually implemented in a way that's full and effective. So we're very eager to work with you, and I think it's also very important that the legislation does include the role of civil liberties and open government organizations, as well as the private sector, to help ensure that the process moves forward effectively. And I think working together, perhaps we can really make that difference.
I would agree with Ms. Frederickson. I would also note that some of the provisions in this bill will be really important government-wide. And one of, I think, the most important ones for congressional oversight is the audits and the provision in the bill that also tracks the markings and uses by individual employees. I think both of those, that should include a report to Congress also, some not about specified individuals. But I think a reporting requirement to Congress and to the appropriate committees, yours for DHS and others as this goes out further, are essential to both the public trust in this and to Congress's ability to engage in oversight. And then I also think the two other provisions, the ability for the public to ask for removal, because that gets this out in a more transparent realm, and the ability of employees to challenge the markings is critical. And again, protection for employees that do that, because it's very nice to say they have the ability, but we know from experience that those challenges often lead to repercussions on the employees.
If I could just add a couple other points. I think it's very important for Congress to keep in mind the impact of this on the Freedom of Information Act, and to not permit a memorandum that sets up the CUI framework to undermine the FOIA, which is a congressionally enacted statute. I also think that Congress should be keeping an eye on the development of substantive definitions for CUI within each agency. This committee looks at the Department of Homeland Security, but every other committee should be looking at their own agencies that they conduct oversight over, and make sure that the CUI definition does not become too expansive. And finally, and this relates to what Ms. McDermott just said, I think it's important for Congress to keep an eye on how this is working, because as I mentioned in my testimony, these trusted pathways could be corrupted just like an agency could be corrupted. In order for them to work, we need to make sure that those who are sharing the information understand that they're expected to use it properly and use those trusted pathways to help protect the country.
Sure. Yeah, I appreciate all of those answers, and I think this legislation could be and should be a model government-wide. I think Mr. Dent raised the question: should we? This applies to the Department of Homeland Security, but should it be government-wide? And I clearly think it should. It runs classifying information, runs the gamut. I think we've all been frustrated, by this overclassification in a number of areas, and it seems to run the gamut from doing it out of an abundance of caution to maybe protecting politically sensitive or embarrassing information, to just pure laziness. We've all been frustrated by those of us who see classified information. A lot of times we look at it and say, and we've asked often, is there really a need to classify this? What is classified about this information? And I think it does come down sometimes to just pure laziness. We need someone that's going to actually ask the question, why do we really need to classify this information? So I think this legislation moves us in the right direction, so that we can ensure that the public has access to information it needs, that we get information that may be sensitive into the hands of those who need to see it, so we're ensuring proper information sharing, and then really only classifying those things that really do need to be classified. So I commend the chair for the legislation and for the hearing, and with that I'll yield back. Thank you.
Thank you, Mr. Langevin. I've asked the members to my right whether they have additional questions. They don't. Do you have any additional questions? Well, okay, then let me just make a couple of comments and we'll adjourn, followed by the markup that has been announced in 15 minutes after adjournment of the 4 bills. My comments are as follows. First, thank you to our witnesses and to other outside groups and administration experts for contributing to our work on this piece of legislation. I think it is a much better piece of legislation because we consulted widely and because we worked together. Mr. Reichert and his staff were enormously helpful in improving the legislation. Secondly, we're building on a Bush administration framework. I am saying this, it is true. Ambassador McNamara is the fellow who came out with the CUI guidelines. He was tasked to do this, and we are trying to find a way to make DHS, the Department of Homeland Security, the gold standard for implementing those guidelines correctly. So here we have a committee of Congress building on Bush administration guidelines. It will be a rare, I think, final example of such a thing, but I think we're going to build something important because of the way we worked on this. Finally, one of you was talking about the need to involve the public in advance. I think this is what you said, or this is certainly what I wanted you to say, because I agree with it, in advance in understanding the terror threats we face. Let's understand what the motivation of terrorists is. They want to terrify us. Some of them may also want to kill as many of us as possible, but that is the point of their activity, is to terrify us. I believe that an informed and prepared public is much less likely to be terrified. How do we inform the public? Well, part of it is sharing information with the public, having a presumption that unless there's a good reason not to share it, it must be shared. And secondly, having public officials who, in a thoughtful and useful way, brief the public on what the threats are and what to do to protect themselves. Not terrify them, not scare them, brief them, inform them. An informed public, I think, is our best protection of democracy. It's also our best protection against terrorism. So I want to say that by doing this legislation and by enacting the other bills on public access that we will enact, I believe we will enact today on a unanimous basis, I think we're taking a giant step toward one of the big missions of this committee, which is protecting the homeland. I want to thank you all for your contribution to this. And I also want to say that if any members have additional questions for the witnesses, we will ask you to respond expeditiously in writing to those questions. Hearing no further business, the subcommittee stands adjourned. A quorum being present, the subcommittee will come to order. I notice that we have 4 members. A quorum is 3, but Mr. Langevin is on his way, and I would urge all members to remain through this markup, which will not last very long, because 5 members are needed to forward the bills to the full committee, and I would hope we would have 5 members at the conclusion of the markup. Today we are meeting to consider 4 measures. H.R. 6193, the Improving Public Access to Documents Act of 2005, which was the subject of a hearing we just held. H.R. 4806, the Reducing Overclassification Act of 2007, which has been the subject of hearings in this subcommittee. H.R. 3815, the Homeland Security Open Source Information Enhancement Act of 2007, a bill introduced by Congressman Perlmutter, and H.R. 6098, the Personnel Reimbursement for Intelligence Cooperation and Enhancement of Homeland Security Act, a bill which has no acronym that I could possibly pronounce, introduced by the ranking member, Mr. Reichert. I now recognize myself to make a very brief opening statement. Today I am pleased we are considering 4 bills that begin to address the obstacles that stand in the way of more and better information sharing between DHS and its state, local, and tribal and private sector partners. These measures were drafted to be included in the fiscal year 2009 authorization package, and I hope that will happen. I appreciate the collaborative approach that the ranking member, Mr. Reichert, Mr. Perlmutter, and other members have taken during this process. There has been discussion with all our members. Information was released as required in advance, and so far as I know, everyone had a chance to participate. H.R. 6193, the Improving Public Access to Documents Act of 2008, addresses the out-of-control, sensitive but unclassified system that has been used to deny the public access to information. This bill sets strict limits, reducing from over 100 to just 7 the number of permitted control markings on unclassified information, and putting in place at DHS strict standards and training to ensure those markings are properly applied. H.R. 4806, the Reducing Overclassification Act of 2007, dovetails with H.R. 6193, requiring the Secretary of DHS to develop a parallel system that extends the same training and enforcement mechanisms to DHS personnel who have classification authority. The legislation will help prevent overclassification by making sure that DHS uses the classification regime as it was intended, to protect sources and methods, not to hide embarrassing facts or to protect turf. H.R. 3815, the Homeland Security Open Source Information Enhancement Act of 2007, breathes new life into DHS's floundering open source program, helping to improve information sharing by requiring DHS to create unclassified intelligence products based on publicly available information. And finally, H.R. 6098, the Personnel Reimbursement for Intelligence Cooperation and Enhancement of Homeland Security Act, confirms our intent in last year's 9/11 Act by requiring DHS to permit state and local authorities to use grant funds to hire and keep on staff Fusion Center analysts for however long state and locals see fit. All of these bills will move DHS intelligence and support for our for our nation's state, local, and tribal first preventers firmly in the right direction to making the homeland more secure and making the public more informed. I now recognize the ranking member, the gentleman from Washington, Mr. Reichert, to make an opening statement.
Thank you, Madam Chair, and thank you for holding this markup today. We are meeting to consider some vital issues that affect our nation's homeland security. As I mentioned in my opening statement from the hearing we just held, I look forward to working with you as these bills move through the committee process. One of the issues that I've worked hard on for the last 3.5 years is grant funding and ensuring that state and local cops and other first responders are getting what they need in the way of resources and financial support. I'm grateful that we have the opportunity today to address some of their concerns by taking up H.R. 6098, the Price of Homeland Security Act, which I have sponsored and is co-sponsored by a majority of our subcommittee's members. It's also received the support of the Major City Police Chiefs Association and the National Sheriff's Association, and would ask unanimous consent to insert into the record a letter from the Major City Chiefs this morning. Without objection.
So ordered.
It is essential that we move this bill quickly to the House floor. In my home state, I know my speech is riveting. In my home state of Washington, there is potential reduction in staffing in our fusion centers, the Washington Joint Analytical Center, and if changes aren't made. While we are hoping for a temporary solution in Washington state, a long-term fix is needed. My bill is simple. It clarifies congressional intent for grant funding. As a part of H.R. 1 last year, we tried to make it clear to the Department of Homeland Security that states and localities should have the flexibility to use grant fundings for fusion center intel analysts or, where needed, for overtime and backfill costs. Unfortunately, the Department of and the Office of Management and Budget decided to go their own way in grant funding issues. I was especially dismayed when grant guidance was released in February. Because of some of the restrictions contained in this guidance, I respectfully contacted the department to ask them to reconsider their restrictions on grant funding, especially the restrictions on the analysts and personnel. This effort resulted in a March 20th letter in 2008, a letter to Secretary Chertoff and OMB Director Nussel, asking them to revise their grant guidance in accordance with the 9/11 Act. And I, Madam Chair, ask unanimous consent that this letter be inserted into the record.
Without objection.
While this letter and the letters of others were partially successful in alleviating some of the challenges that are being faced by our state and local fusion centers, DHS is still placing unwarranted restrictions on grants for fusion center personnel. DHS and OMB try to explain that they don't want to pay for the state and local police, but our state and local cops are our frontline first preventers. As we saw in Torrance, in Chair Harmon's backyard, state and local law enforcement are most likely to encounter terrorists living among us. Their counterterrorism responsibilities deserve as much federal support as we can give them. I introduced H.R. 6098, the Price of Homeland Security Act. It is a small price to pay to ensure that our fusion centers are adequately staffed. In this amendment, in the nature of a substitute to H.R. 6098, we hope to add a provision that will allow grant recipients to use up to 50% of grant awards to pay for personnel and operational costs, including overtime and backfill costs. This is another area where DHS and OMB either misunderstood or ignored congressional intent. This bill is essential for our first preventers and for the states that are struggling to protect our citizens from harm. Madam Chair, I applaud you for bringing up this important bill, and I yield back the balance of my time.
I thank you, Mr. Reichert, and appreciate being told the acronym for your bill, the Price of Homeland Security Act. Very impressive. We usually, under committee rules, waive any opening statements of other members. However, because I'm about to offer a unanimous consent request, which will basically end discussion of these bills, I'm prepared to ask unanimous consent for any other member to make an opening statement. Would anyone like to make an opening statement? Okay. In that case, I now call up H.R. 6193, H.R. 4806, H.R. 3815, and H.R. 6098. These bills were circulated in advance, as I have said. Without objection, the readings are dispensed with. In consultation with the ranking member of the subcommittee, and because of we anticipated a lot of activity on the floor today, without objection, these four bills are each adopted by the subcommittee as amended by the corresponding amendment in the nature of a substitute as listed on the roster. Any objection? Without objection, each measure as amended is forwarded to the full committee with a favorable recommendation. And, without objection, staff is authorized to make any technical and conforming changes, and let me take this opportunity to thank staff on a bipartisan basis for working with members who were extensively involved on these bills, and for working with outside groups whose input, as we said in the hearing earlier today, was very significant. Both groups outside and inside the administration played a role in improving these bills. There being no further business, the subcommittee and this markup stands adjourned.